All right, welcome everybody. Thank you guys so much. I am so excited to present Doug Dean and more specifically Amanda McGowan with the closing law firm of Shafritz Dean, and we're going to learn all about liens. So thank you guys so much. Take it away.
Okay, so hi, as Doug said, my name's Amanda. So we're going to talk about liens. So first of all, basically, just want to start with what a lien is. So a lien is just a legal claim against a property. It can be used by a creditor to obtain repayment on a debt. So there are a lot of different types of liens, and your handout will just go over the most common types of liens and kind of what those are, and then we'll talk about how long they last and how we clear them and deal with them if they do show up. So you have a judgment lien, which is a lien that is placed on a property after a judgment in a lawsuit. So it can be any underlying type of case. If there's a judgment, the person who gets that judgment then can put a lien against the property that the person owns, that the person the judgment is against owns. When you see that on a title or you see the document, it's called a FIFE, and so that's a judgment lien. And then you have property tax lien, which is what it sounds like. It's a lien if the owner of the property hasn't paid the property taxes. The county will put a lien on the property for that. Income tax lien. So if they haven't paid their income taxes, either state or federal, those are the two different kinds that we deal with, and I'll talk about the different requirements, different timelines. We'll talk about those. Security deed is a mortgage. So when you get a loan on a property, you sign a security deed, which grants an interest in the property to the lender. And if that loan is not paid, then the lender has that interest, which is a lien against the property. And then there's a materialman's lien, which is a lien that can be placed on a property by someone who's done work on a property. So a contractor, any type of work on the property, they can place a lien if they're not paid. An HOA lien, again, what it sounds like. Lien for HOA dues or fines. Water lien is for unpaid water. So those are the most common types, and we'll go over those a little more. So for judgment liens and then recorded property tax liens and water liens, the time limit on those is 7 years. So from the time they're recorded, they're in effect for 7 years. And then after that 7 years, they're expired and they don't have to be repaid at closing. So any of these liens, if they show up on the title, they have to be cleared, which means they either have to be paid or we have to have proof that they've already been paid and get a release from the lien holder. And we'll talk about that a little bit too. Or we sometimes, what we often find is that lien is not against our person. So those are the things we look for when we see a lien on the title to see whether they need to be paid or not. So if it's a judgment lien, sometimes people have common names, and so it'll pull up if it's the same name as our seller, and then we will have to find out if this is the same person with that name. And if it is, then it has to be paid or released because it's already been paid, whatever the resolution is. But often it will be just someone with the same name or similar name. And if that's the case,
I was going to say, let's talk about that for a minute, because we always talk about putting a lien on the property, but in most cases, liens are against the individual. They're filed against the name, and they attach to the property that they own. So, for example, all these judgment liens, they don't have property addresses. They don't have legal descriptions. They have the name of the judgment debtor, and the property attaches to all the property they own in the county where the lien is filed. So if you have a judgment debtor who has property in more than one county, the judgment creditor has to file the lien in each county to attach the property that the debtor owns in each of those counties. But the liens are indexed under name, not under address or legal description. And like Amanda said, a lot of names are confusingly similar. I lived in Douglasville, and there was another Doug Dean in Douglasville. We would get each other's mail and phone calls sometimes. But if someone filed a lien against Doug Dean and one of us went to sell the property, the closing attorney would have to determine which Doug Dean is this? Whose property is it attaching to? And that's something that comes up a bit, is common sounding names and clearing the liens, which we do by going back to the judgment creditor and say, we need a little more information. Which Joe Smith is yours? What are the last four of the social? Or a number of different ways that we can verify whether that's our party or not, so we know whether or not the lien attached.
Yeah. So that would be the next step. When we see that on the title search, we would find out if it is our party, or if it's just someone with the same or similar name. Yeah.
So as you as a homeowner, me as a homeowner, if I was about to sell my home and I just wanted to make sure I didn't have any liens or anything like that on my property, could I go to the courthouse? Would it all be listed on that, or I would have to individually contact GSS?
The GSCCA. You can search through there and do lien search. Yeah. Search by name.
I have an expression that everything is easy once you know how. If you call the courthouse, they won't search liens for you, and they'll say, come in and I can show you how to use the computer. It isn't necessarily intuitive, but it's easy once you know how to do it. And you can do it through the GSCCA, do the lien search. The other thing is we can also do just a preliminary title search for you. I've had a seller who approached me and they said, I had a dispute with my contractor and I want to know if he filed a materialman's lien. And I said, well, I can check and let you know if there's anything in the county records.
I have a question. You said that the liens, the judgment liens, they expire after 7 years.
Mm-hmm.
So if you place a lien on someone, and you have to go back and.
So yeah, there's a process for renewing it. So if it's,
Will you repeat the question, please?
oh yeah, sorry. The question is, if you have a lien against someone, what do you have to do at the end of 7 years for it to not expire? So it's called a nulla bona. I never know if I'm pronouncing that correctly or not.
I pronounce it bona. I can't swear to you it's right, but that's what
it's nulla bona or bona. But it's basically just renewing the lien. It renews it for another 7 years, and you can do that indefinitely as long as you don't let it expire. You can renew it until it's paid.
Oh.
Yeah.
And would that show up in the county records when they renew it?
It does.
Okay.
Yeah.
As a matter of fact, our title exam will have a copy of the lien and a copy of the nulla bona showing it was extended.
Mm-hmm.
So I think you answered this for me, but I just want to be clear. So say, for example, you have a tenant. The tenant hires a contractor. They have an issue. And then the tenant doesn't pay that contractor. But you are the homeowner. But the contract was done under the tenant's name. So that would follow the tenant. It wouldn't get applied to the property, even though it was work done on the property.
The answer is you are correct. A materialman's lien, when you read the lien statute, it's only a lien for work or supplies provided at the direction of the owner. So a materialman does not have lien rights for tenant ordered work because they're not the owner of the property. And when you think about it intuitively, that seems kind of fair. As an owner of the property, it wouldn't be fair to me that some tenant ordered some work, didn't pay it, and left me with a lien against the property. So they would still be able to sue the tenant, get a judgment, collect, and all the different ways that creditors collect against debtors. But what they couldn't do is create a materialman's lien against the property unless they can show that the owner consented or ordered the materials, the labor, and so forth.
And when they when they go to that process for a lien, they have to contact you or something or get a judgment or something.
Oh, there's a notice. There is a notice provision. They are required. They don't just file it in the county, but they do give notice. Now, the other one that works like that are water bills. The state statute said water bills are liens only if they're in the name of the owner of the property. So tenant water bills do not create liens against the property.
Okay. All right. So, and then, so we were on judgment liens. So we talked about renewing them with a nulla bona. And then we'll just go over quickly income tax liens. So there are state and federal.
Just real quickly on judgment liens, remember when we go to get a judgment lien payoff, judgment creditors are entitled to, in most cases, attorney fees and interest at the level set by statute, what we call statutory interest. So a lot of times we go to get a payoff, it's more than the face value of the lien. It's face value plus collection cost and interest and so forth.
Yeah. Yep. All right. So the state income tax liens, they are, the timeline for those is 10 years. Federal tax liens is 10 years plus 30 days from the date of assessment. Federal tax liens actually on the face of them will have it says the last day for revaluing. That's the day that those expire. Those you also can clear those sometimes with similar names. So again, those like judgment liens are against a person, a name, not a property. So again, we would check the name, check the social security number, make sure that matches to make sure it's the same person. And if it is, then we have to get a payoff on that to get the final balance that needs to be paid to clear that. Okay, so then we're going to talk about material liens, so we'll go into a little more detail on that. So, sorry, could you repeat that question? We were
If the contractor, I'll just say contractor, is working on a property and the tenant hired the contractor,
the tenant
contractor wants to get paid,
and they
the
go.
tenant doesn't pay them, and they go and find out who the owner is. Although they know they work with the tenant, and they put a lien on the canvas lien against the owner of the property. How do they get rid of that? Because some people would have done that.
Yeah. Well, like Doug was saying, the contract would be with the tenant, so they wouldn't have the owner wouldn't be a party to that contract, so they couldn't record a material lien. And if they did, it would be the defense of that. The owner's defense of that would be they weren't a party to the contract.
Yeah. And they would have to go through the courts and get that removed. I mean, they still have to do something.
When a materialman files a materialman's lien against the owner, the lien is good for, and I believe we'll touch on it, 395 days.
Well,
that you can only file a lien for work or materials provided in the past 90 days. So you have to file the lien within 90 days of work and material. Once filed, the lien is good for 395 days, but the owner can file a notice of contest of lien that says, I don't believe this lien is valid for whatever reason, and it shortens it from 395 days to 60 days. And if unless the materialman files suit to perfect the lien within 60 days, it will go away. If they do file suit, the homeowner has whatever defenses are available to them. I didn't order this work and materials. It's therefore not a lien against my property. And even if they did order it and they had dispute with the contractor, they'd still have the right to file a notice of contest of lien and raise those remedies and defenses if the contractor files suit to perfect the lien.
Okay. And then HOA liens, so those have 4-year time limit. However, if the HOA does file a lawsuit to recover the fines, dues, whatever, then it becomes a judgment. If they get a judgment from that lawsuit, then it becomes a judgment lien. And then it's treated like any other judgment lien. But the HOA can file a lien directly, and those liens are 4 years.
Just real quick, it's important to know the difference. If you're in a planned unit development or a condo, the owners association can just file a lien and says, we're claiming a lien against the property because the owner has done whatever, typically not paid the dues, or they're in violation for some other reason that they claim a lien, and that's an HOA lien. The HOA can also sue the owner for the deficiency, for the money that's owed, and get a court judgment which is recorded, and now that is a judgment lien, which is different than just like we spoke about earlier, like any judgment lien. And a lien filed by an HOA or condo owners association is good for 4 years. If they sue and get a judgment, it's good for 7 years, and that 7 years can be extended.
Yeah, like any other judgment lien, they can do an LL. All right, and then security deeds. So like we were talking about earlier, that's what you sign when you get a loan on a property, a mortgage. Though generally, not always, but generally there will be a maturity date on the security lien, which is when the loan is due to be completely paid. So those expire, or it's called reverting back to the grantor, because owner of the property grants the deed to the lender. So it goes back to the owner of the property after the expiration of the deed, which changed in 1994. So if that security deed was signed prior to April 19th, I want to say 19th of 1994, then the expiration is 20 years from the maturity date. If it was after that date, it's 7 years from the maturity date. So there are cases, though, where there's not a maturity date. If there's no maturity date, then it's 20 years from the date it was executed is when it would expire. Some security deeds will have language that says it's perpetual, which is usually a home equity line of credit, something that you can continue to draw on. So it's not a set repayment period and a set timeline on the loan. So those will have language that it is a perpetual loan, and those you just have to get that release from the lender. So those don't expire. So those are the different types of security deeds that we deal with. And then I think those are the main types of liens and how they work and how the timeline on them. And then, like we've kind of touched on a little bit, what we do if they do show up, if there is a lien, depending on the type, we look at if it's expired, if it's still in effect, and then we find out if it's our person, if it is the same person with the same, or a different person with the same name. If it is the same person, then we get a payoff, or we clear it somehow, or get a release from the lender if it's been paid and just hasn't been released of record.
Another thing to know about security deeds, because we see it a lot, was when people got some type of like a forbearance or modification to their existing loan, and typically either the lender or HUD took a second lien against the property for the amount that was forgiven. So it didn't go away, and so our seller says, I only have one loan. Our title comes back and says, well, you have two. You remember you got that forbearance with HUD, and they're owed $7,000. So it comes up a lot that people forget about those.
I think a lot of people don't know it. They get the forbearance and modification, and they don't realize that it's not just being forgiven. It is, or just being added to the end of your loan. It is a second loan.
She won't sell the house.
Remember that regardless of what type of lien it is, if a lien is filed against a person, whether it's husband or spouse, whichever, it attaches to all the property they own, and it stays attached. And let's use the argument, you and your ex-wife were married, you own the property together, and somebody got a lien against her, it attached to the property she owned. Now in the divorce, one of the things we look at is, were there liens, and what did the court say, who's responsible, and did they pay them? It might say, you are awarded title to the property, and your spouse must pay that lien against the property. If the divorce decree doesn't tell us that, it's a lien against the property, and even though she came off title in the divorce, the lien is still attached because it attached when she was on title. The other thing to know about these type of liens is that we have a lot of times where people say, I want to add someone to title. And I tell them, it's easily done. It's hard to undo. You want to add your boyfriend or girlfriend to title. And the first thing I tell them is, you're giving them a gift of a half interest in the property, and you can't easily take it back. It might violate the lender's due on sale clause in the note in the security deed that say you may not transfer your legal interest in the property without the lender's consent. And once you've done it, you have a falling out, they don't have to give it back. And we run into these from time to time, so which is why when we do deed preparation only, we give them a disclosure that tells them all of these things. And the other thing I tell people, when they're engaged, I said, just wait until you're married. When you're married, it doesn't violate the due on sale clause. There's a federal law exception for transfers between family members. So, And the other thing is, sometimes people are engaged, wind up not getting married. And we had to help a couple in that situation where he had it his fiance to the title. They broke off the engagement. She wouldn't give the title back. He had to sue her. And the judge ruled, yeah, she will sign the deed back to you, but you should give her $7,000 because of the appreciation in the property. So even though she never put money into the property, she got $7,000 coming out. But what it does illustrate is the legal principle that liens are attached by name and they attach to the property that they own. So if you have someone on title who gets a lien against them, even if they later come off title, the lien already attached while they owned it. We have lots of problems with county taxes because the taxes occur whether you get notice or not. Everyone who buys a home this year, the tax notice is going to go to the owner of record January 1st, not the person who bought this year. And you don't get out because you say, well, I didn't get the bill. So just being aware, yes, and most people have an escrow and their lenders take care of that for them. But if you don't have a lender escrow,
I did.
There were
an escrow too.
along those lines. If you, as an agent, there were a lot of cash deals the past year. If you, as an agent, had a buyer that paid cash for a house, this is a great issue to bring to their attention that they may not get that property tax bill and they need to go find it.
Right.
So you guys, a couple of things too, and then we'll wrap up on liens, and then we can ask Doug and Amanda any additional questions. You guys see those commercials about who get rich in real estate, buy tax liens, buy tax liens. Again, as Amanda and Doug said, there is a redemption period where the owner can come back and redeem that house. So if you have an investor that's just taken a new course or seen a commercial on TV and they're going to get rich by buying tax liens.
And I heard you have to actually foreclose on it even after that year. Is that true?
sure, we can talk about tax liens in detail another time. But the short version is if you don't pay your taxes, the county will sell your taxes. So county will sell your taxes at auction. And the buyer is called a tax deed buyer. But a tax deed doesn't allow you to enter the property. It's not a present possessory interest because you bought a tax deed. They can stay there, and they have a year that they can give you back what you paid plus 20% until you go away. I'm redeeming it from the tax deed. And even after the year, there's a whole legal process to foreclose the right of redemption. And part of that in most cases is you have to file a quiet title action to get good title. So buying a tax deed, the easiest thing is get your money back plus 20% in a year. That's a pretty good return. So getting it redeemed may be the easiest thing. Wanting to get title, you got to wait a year, foreclose the right of redemption, and file for quiet title.
Well, Amanda and Doug, thank you so much. Y'all can ask more questions. I'm just going to turn off the video. Thank you for great information on liens. They're a little more complicated than you first think. So please contact Doug and Amanda. Shafritz Dean is the closing attorney law firm, and they can answer all of your questions and help you with all of your closing needs. Thank you guys
Thank
so
you,
much. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.